I think we will go ahead and get started. This is another unusual month under these unusual circumstances. I want to welcome all of you who are participating to another meeting of the First Friday Breakfast Club, this one in virtual reality. And at this point, pleased that as many of you who have joined in on this virtual meeting. I want to also remind folks to give some thought to checking our website, ffbciowa.org, because there you can go back and hear the audio of our speaker at a prior meeting. So if you miss a meeting or you want to hear something said again, you can go to the website and access those audios. These are, as I say, unusual times, and people keep saying that. They are what they are. At this point, we've been able to stay on top of getting the newsletter out. You should have received your most recent issue just in the last few days. The next copy deadline for anyone who has something that you would like to contribute, or in particular, our regular contributors, our next copy deadline will be May the 11th. That's a week from next Monday. We will also be doing our FFBC board meeting next Tuesday at 6:30 p.m. And we will also be doing that virtually. And I want to thank our newest board member, David Cotton, for helping out with the coordination of these virtual meetings, both of the full group as well as our board of directors. If you need any assistance, not this time, obviously, but the next time we might have some virtual meeting and need assistance in getting it figured out, if you'll get in touch with me or David Cotton, we can coordinate walking you through the steps to participate going forward. On a great note, and the FFBC has selected 7 new scholarship recipients that will be awarded upcoming. They are from all over the state of Iowa, and that means we will be investing another $21,000 in scholarships for post-high school education for students who have done courageous things in their high schools to educate on LGBTQ issues and advocate for equality. And with that, we will have awarded more than $325,000 in scholarships to deserving students dating back to our first scholarship in 1996. There has not been a decision made yet regarding our June meeting. That will be discussed by the board at its board meeting and periodically thereafter until a decision about that is made. I certainly would prefer to have an in-person meeting that would include those students and their families and give them the wonderful, warm, welcoming environment that past recipients have had at the meeting in June. That may not be possible this year, and the board will simply have to be discussing what options we might have and what other things we might be able to do to recognize these students. Are there any other announcements? Hearing none, we will turn to our speaker and let you know that as we go along, he is open to questions, as well as when he is finished with his introductory remarks, he will be happy to take questions from you at that time as well. And with that, I will turn to Scott Kuknio, who's going to introduce our speaker for this morning. Scott.
Good morning, everyone.
Morning.
24 years as a U.S. District Judge in the Northern District of Iowa, Bennett retired on March 2nd, 2019. to accept the first director of the Drake University Law School's Institute for Justice Reform and Innovation. From 1991 to 1994, he was a U.S. magistrate judge in the Southern District of Iowa. He was in private practice in Des Moines from 1975 to 1991, having started his own law firm upon graduation from Drake University Law School in '75. For 16 and a half years, he practiced primarily in civil rights, civil liberties, and employment law on behalf of plaintiffs and defendants appearing in more than 30 federal district courts, several of the Court of Appeals, and the United States Supreme Court. He argued his first case in the Supreme Court less than 4 years out of law school. He had 3 more cert petitions granted before he was 32. He was taught at the University of Iowa College of Law, the Drake University Law School, the University of Hawaii William S. Richardson School of Law, and the University of Nebraska College of Law. He's also on the faculty of the National Center for State Courts and a judicial fellow for the NYU Civil Jury Project. In the past 9 years, he's authored 27 law review articles, many on various aspects of trial practice, often on issues involving intersecting law and cognitive psychology. He's been involved in educating more than 3,500 state and federal trial and appellate judges from Alaska to Florida and Maine to Hawaii on implicit bias, and many more lawyers and court staff. He was the first judge in the nation to both discuss implicit bias with potential jurors and to give a written instruction on implicit bias. He's authored numerous other articles, most often about judging and trial lawyers, is the co-author of a treatise on employment law, has spoken at more than 500 CLE programs in 39 states and several foreign countries. Bennett has sat by designation in the district courts of Arizona, Idaho, the Middle District of Florida, North Dakota, and the Northern Mariana Islands, as well as the 8th and 9th Circuit Courts of Appeal. Judge Mark Bennett.
Thank you very much, Scott, for that really gracious introduction. I'm very honored to be with you this morning, and hope you enjoy your breakfast. Jonathan was kind enough to send virtual cinnamon rolls to all of us, so if I'm chewing, that's why. So I wanted to tell you a little bit about my experiences. I started as a federal district court judge in 1994 in Sioux City, and surprisingly, we had a very, very heavy criminal caseload. There are 94 federal districts in the country. And we were usually, during my 24 years, either 5th or 6th in the nation in terms of the number of criminal cases per judge. So for example, if you took a federal district court judge in the District of Columbia, the Southern District of New York, the Northern District of Illinois, which is Chicago, the District of Minnesota, and the Northern District of California, which is San Francisco, and you added their criminal caseload together, the other judge and I in the Northern District had a heavier criminal caseload than that composite. So in my 24 years as a district court judge, I've sentenced more than 4,000 defendants. And I was a pretty good case manager, so I was able to manage my docket. And so I frequently helped out other districts that had a shortage of judges or just had tremendous caseloads. So for example, I spent a couple of years going back and forth to Arizona, helping them out, in over 500 criminal cases. And my best gig was in the Northern Mariana Islands in Saipan, where I was a visiting judge for 2 years. So I handled my docket in the Northern District, and then every other month or so, I would fly to Saipan and handle their trials and sentencing. And then when I was back in Sioux City, I did a lot of work on their cases remotely. The timing was great because at 5 o'clock Iowa time, it was 8 in the morning, Saipan time the next day. And so I was able to do quite a bit of their work in the evenings and keep their docket current. So as a federal district court judge, you have a wide variety of cases. So I've handled everything, as all district court judges have, everything from virtually every kind of criminal case you can imagine, but the biggest ones in our district were drugs, very heavy methamphetamine caseload. So drugs, guns, and immigration. Usually two of the three, sometimes all three in the same case, would be the bulk of the criminal cases, but also handle white collar, securities fraud, antitrust, fraud cases, all different types of criminal cases. On the civil side, everything from banking disputes, commercial litigation, a lot of employment litigation, prisoner rights cases, which I found very interesting, and a whole variety of civil rights and civil liberties cases. Probably the cases that I remember most are I handled 2 federal death penalty cases, which is very rare. They were just the 53rd and 54th defendants on federal death row, and I'll come back to that in a minute, but it's kind of an interesting story. When I was being vetted by the Justice Department back in 1994 for the federal district court judge position, I was in Washington, D.C., meeting with the Attorney General of the United States, Janet Reno, and her staff, about 8 of them in a room, and they were grilling me. And they asked me what my views on the death penalty were. I said, well, I've always been personally opposed to it. I doubt that that will change. And then they said, well, what would you do if you got a federal death penalty case? I said, well, the odds of that are extremely rare, so it's not really anything I've given any thought to. It's so unlikely. There's never been a federal death penalty case in either the Northern District or the Southern District of Iowa. So I said I'd look at it at the time, and if I thought I could enforce federal law, I would keep the case. If I thought my personal opinion would prevent me from being fair and impartial, I would what we call recuse myself. And Janet Reno looked at me and she said, you can't give that answer in your confirmation hearing. And I didn't exactly know what she meant by that, but I said, that's the only answer I have. So if I get asked, that's the answer I'm going to give. And if that's not good enough, that's fine with me. But I'm not going to basically whore myself to tell the Senate Judiciary Committee something I think they want to hear. And they were kind of taken aback by it. And that was actually right before I was nominated. They were vetting 4 of us. And so I thought that kind of torpedoed my chances. But it did not, and President Clinton nominated me. And fortunately, despite my controversial background of I'd represented the Ku Klux Klan, the Hare Krishnas, Reverend Moon and the Unification Church, the Socialist Party, the Nazi Party. I'd even brought one of the first gay marriage cases in the United States for the ACLU in Iowa. We lost in the trial court, and I persuaded the clients and the board not to appeal because I just thought the timing wasn't right. And eventually we would get there, and thank God we got there. It took way too long. So the 2 death penalty cases were interesting because federal death penalty law is very complex. And so we were 5 years in pretrial motions in the 2 cases. They had to be severed because some evidence was admissible against one defendant, some not admissible against the other defendant. They were boyfriend, girlfriend, and they were accused of killing 5 people in furtherance of a major drug trafficking case. And I ultimately decided when the cases were assigned to me that I could apply the law, and it's the only time in federal court where the jury decides the penalty. So in a death penalty case, once you've gone through the guilt, not guilty phase, and the jury finds the defendant guilty, then you have a continuation of the trial in a penalty phase where the jury hears evidence from both sides if the defense presents evidence, which they did, not much. And then the jury decides whether it's life or death. And in both Angela Johnson's case and Dustin Hawkins' case, the jury imposed the death penalty. Dustin Hawkins was probably the most dangerous defendant that had ever appeared before me. He had threatened to kill virtually everybody in the trial. The government had an informant in his cell I had previously sentenced him to 27 years on a related drug case where the government tried to convince me that he had murdered some people, but they didn't have much evidence at that time. They had no bodies, and I just said I wasn't going to find that he murdered them, but you're always free to re-indict him on those charges if you develop enough evidence. And several years later, they did that. In Dustin Hawkins' case, we had 6 U.S. Marshals living in our home for about 5 months. And my daughter was starting public high school in Sioux City at North High as a freshman. And she had 2 U.S. Marshals at her side 24/7. One would sit next to her in the classroom and one outside the classroom door because the defendant had threatened to kill everybody involved in the case. And so the U.S. Marshals did a threat assessment. That's why we had the Marshals living in our home. We did have one, a couple of funny incidents. We had, there was a practice in Sioux City at homecoming where they would TP, put toilet paper on trees, target various people. And we lived on a small acreage, and the house next to us, a very good friend of mine, a dentist, had a daughter who was my daughter's doubles partner in tennis. And some boys showed up at about midnight to TP that house. And in the middle of TPing, they were surrounded by several U.S. Marshals. I guess I had neglected to tell the Marshals about the practice. And they came from all over the country. And so these poor high school boys were surrounded by U.S. Marshals with assault rifles, and several of them wet their pants. And so that was one of the funny episodes. Another really funny one for me was we had a great group of U.S. Marshals, and one was from Omaha. He would come up for 2 weeks, 2 weeks off, come back. And he was a all Big Ten football player at Iowa, Grant. I can't remember his last name. He was a fullback. And my daughter wanted to go. They wanted us to try and lead ordinary lives, which is a little difficult when Marshals are in your home. But my daughter wanted to go to the shopping mall, so they took my daughter shopping, and she met 2 of her girlfriends. And all of a sudden, it was a Saturday afternoon, and I was in my chambers working. I get a call from my daughter, and my daughter says, "Dad, I've lost Grant. I don't see him anywhere. Is he going to be in trouble?" I said, "No, I'm sure you didn't lose him. Just relax, and if you don't see him in the next 5 or 10 minutes, call me back and I'll call him." And about 2 minutes later, I got a call from Grant, and he said, "Oh, Judge, don't worry. We were just giving your daughter a little bit of space." But it kind of said a lot about my daughter because she was worried that Grant was going to be in trouble. So there were some funny incidents that occurred out of it, but it was, probably the most memorable experiences as federal district court judge, because you rarely get to try a case of that magnitude. I ultimately set aside the death penalty verdict several years later in a very complex post-conviction proceeding. We had 19 days of testimony, 57 witnesses, and I concluded that Angela Johnson's defense was totally ineffective, and they really dropped the ball on a lot of things that you couldn't tell during the trial, but the evidence after the trial clearly established that. So I set aside her death sentence, and she's serving a life sentence now. Dustin Hawkins, on the other hand, his sentence was affirmed by the district court, the Court of Appeals in the U.S. Supreme Court. He was supposed to be executed in this past January, but a stay was issued because of issues relating to the drug cocktail that they use in federal executions. But there are still now only 60-some people on federal death row. So those are probably the 2 most memorable cases, but every case was important to the litigant, and it's really important for judges and their staff to remember that you can't just focus on what you think are the big important cases, because every litigant that comes in front of you, that case is exceptionally important to them. And so I really drilled that into my staff. But I think Jonathan called me because there was an article a while ago in the Des Moines Register about my visiting inmates that I had personally sentenced. So I'm going to kind of transition and talk about that. And I've always been interested and kind of fascinated by prisons, and also kind of scared by them. When I was a very young lawyer, I worked down at Fort Madison on a prisoners' rights project, and represented inmates in a variety of legal matters. And that was kind of my first exposure to prison life. So I was out in Long Beach. I was giving a speech to a group of judges out in Long Beach. This would have been in the probably mid to late 90s, I guess the late 90s. And I had just sentenced a group of bank robbers that had come to, they were Los Angeles gangbangers. And it was really kind of a funny story. They flew into Omaha, 4 guys, 2 brothers and 2 of their friends, and took a cab from Omaha up to Sioux City, and got out, and the next day stole a car, robbed a bank, took a cab back to the airport in Omaha, flew back to South Central, to Los Angeles, and continued on their way. The bank robbery was never solved. And a couple years later, they fly into Omaha. As luck would have it, they get the same cab driver that they had a couple years earlier, and he drives them up to Sioux City. It's 100 miles. And he thought they must be drug dealers. So he calls, after he drops them off in Sioux City, he calls the DEA and explains he has a hunch that they're drug dealers. The next day, they steal a car. They rob the same bank in the same fashion. They drive in backwards into the drive-in lane to block it, and then get out with masks, rob the bank. And as soon as the teller saw him in the driveway, she yelled, "They're back." Yeah, because she recognized that it was kind of a signature crime. And they had learned through their bank robberies that banks throw in dye packs, which explode, and then that dye gets all over people. So it helps identify the people as the bank robbers if they're caught, because it's very hard to get the dye off, at least in the first 48 hours or so. So in the second robbery, they took all the money, and they had a big cooler filled with water, and they put it in, and then the dye pack exploded, and it didn't get on them, but they had all this wet money. So they take this wet money and they stuff it in various parts of their body. And they take a cab back to Omaha. And by this time, the DEA agents had figured out maybe these were the bank robbers. And so they get to the airport at Omaha just as the guys are getting out of the cab, and they split up, and FBI agents take them individually and ask them what they were doing. And of course, they didn't have their stories straight at all. And so when they patted them down for weapons, they found this wet money, mostly in their boots. And so everyone had a different story about why they had wet money. But the best one of the 4 was a guy said, well, they were walking along the river in Sioux City, and the gambling boat went by. And all of a sudden, this money came flying out of the back of the gambling boat. So they waded into the water and picked it up. And that's why they had the wet money. Anyway, so they were really great. The 4 of them, I got along great with them. Ultimately, they pled guilty. I sentenced them. And they were from Los Angeles, so I recommended to the Bureau of Prisons a prison just south of Los Angeles in Long Beach, the worst name in the world for a prison, called Terminal Island. Not a very good place by name, but it was actually a really nice facility. And so the next year when I was giving this speech in Long Beach, I thought, well, I know there's a prison there because I sent these South Central fellows there. and I ought to go visit the prison. So I called the prison, talked to the warden. It happened the warden was Fort Dodge, so we knew some people in common. So gave my speech, and then I went over to the prison and went through all the security, and then the warden gave me a tour of the prison. And at the end of the tour, I said, you know, and I hadn't really thought about it before. I said, I'd really like to meet with some inmates, but I've recently sentenced 4 fellows, and I think we got along great, but I don't want to meet with anybody that I personally sentenced. And so the warden picked a Latino, African-American fellow, and a Caucasian, and I asked to be just put in a room with them with no staff. And I asked, obviously, for nonviolent offenders. So I sat in a room with 3 people I had never met, introduced myself. First, I just said, well, my name's Mark, and the warden has graciously allowed me to come in, and I just want to talk about your experience here in prison. So they started pressing me about who I am. So I finally said, okay, I'm a federal judge from Iowa, and I just want to find out about your experience in prison. So we talked for about 2 hours. And it was just great, very intimate setting. And my time was up, and I said, you know, I've got to wrap it up. Thank you guys very much. And the African-American inmate sitting right next to me started crying. He was just sobbing. And so I put my hand on his knee, and I said, oh, I'm sorry. I hope nothing I said offended you. I could tell you're very upset. He just sobbed and sobbed. And finally caught his breath, and he said, Judge Bennett, never in my wildest dreams did I ever think I'd be in a room with a federal judge and they'd ask me my opinion about something. And that just resonated with me. And so on the plane back the next day, on the plane back to Iowa, that's all I could think about. And so a few days after I got back, I decided, you know, that was pretty easy, visiting inmates that other judges had sentenced. I really ought to visit the inmates that I've sentenced. And I don't really know why I thought I should do that, but I'm kind of a person of action. So I immediately called the closest federal prison, not very far away, in Yankton, South Dakota, and asked the warden if I could come over, have a tour, and then if I could meet with the inmates that I had sentenced. I was actually the largest populator of that prison, and they had 800 inmates, and about 150 of them were people that I sentenced. So I met in a large group with the inmates. That was my first meeting with inmates that I had sentenced. And I couldn't get them to open up and talk at all. And then one of them, who I remembered quite well, I just called him. I said, why is nobody talking? And he said, well, you're here to raise our sentences, aren't you? And I smiled and I said, oh, I should have told you that I can neither raise nor lower your sentence. So as soon as they found that out, they opened up and we just had a wide-ranging discussion. You know, we talked some about their cases and about the sentences that I gave them. You know, every time I would do that, there'd usually just be 1 or 2 that were pretty disgruntled, maybe angry with me. Some of them had a right to be angry with me because I gave them a pretty stiff sentence. So I would talk to them in a group, and then I would meet with folks individually, one-on-one. And I always carried a notebook with me because there were always things that I could do for them. Their lawyer didn't follow up on some things. It's really important that when they get out, they can get a driver's license so that they had unpaid fines. I would talk to the families about helping getting those fines paid, so it would be a much easier transition when they come into a halfway house. And so I visited inmates. It was kind of, instead of taking vacation, I would visit prisons everywhere from California to Florida and a lot of states in between. Overall, I met with over 500 inmates that I had personally sentenced. And I never really understood why I did it, but I found it one of the most fulfilling things that I've done in my life. And then 2 years ago, I was trying my last case before I was retiring, and it was a complicated heroin overdose case I had agreed to help out in Fargo, North Dakota. Black defendant, all white potential jurors, and really a difficult, gut-wrenching case. And on the way back, I had downloaded on my iPhone a bunch of Brian Stevenson's TED Talks and other presentations that I found on YouTube. Brian Stevenson is a Black civil rights lawyer in Alabama who started the Equal Justice Initiative. And he's a really compelling speaker. And he talked about the power of proximity. And I realized that that's what was involved in my meeting with the inmates that I had sentenced, being proximate to them, sitting next to them in the context of what their life is like in various federal prisons. And there's, you know, it's a very different situation when you're sitting in a room one-on-one with somebody that you sentenced rather than just forgetting about the folks that you had sentenced and never having any contact with them. And I found just being proximate to them and their environment, I've learned a lot about federal prisons, some of the things that prisons do fairly well and some of the things that they don't do very well. And it really shaped my sentencing philosophy, which basically was for most of the defendants I sentenced were low-level, nonviolent drug addicts who were involved in methamphetamine, largely to feed their habit. I could go several years doing 200 and some sentencings a year and not have a single defendant that was represented by hired counsel, because virtually all of the defendants I sentenced were impecunious and had court-appointed lawyers. So they weren't big-time drug dealers making a lot of money. They were low-level, hanging fruit addicts. And when I started in '94, up until 2005, the federal guidelines were mandatory. So the drug sentencings were incredibly stiff. Even though I was considered a lenient sentencer in drug cases, I was pretty tough on white collar. And I was tough on violence, so I was much tougher than the government. But for your typical case that we saw, low-level, nonviolent drug addict, I was considered very lenient, although my average sentence back then was 196 months in a drug case. To me, that's hardly being lenient, but the guidelines were mandatory. And then in 2005, the Supreme Court declared the guidelines unconstitutional, and they became advisory. And within about 2 years, my average sentence was cut in half down to about 90 months. It would have been much lower, but the fact that the guidelines were voluntary, were advisory now, did not affect the mandatory minimums. And so in methamphetamine cases, 5 grams of methamphetamine, which is about the size of a packet of sugar that you would put in your coffee, those 5 grams earn a defendant a 5-year mandatory minimum sentence. And if they have a prior drug conviction, even in state court, even if it's just an aggravated misdemeanor, the prosecutors have a right to file an enhancement that doubles that. And so if somebody has 2 prior, I think this is hard for the public to understand, but if somebody has 2 prior drug convictions, and they could have been aggravated misdemeanors in state court where they paid a couple $100 fine and never served a day in jail, and they're prosecuted for a small amount of methamphetamine in federal court, if it's over 5 grams, their sentence is mandatory life. Mandatory life. Judge has no discretion. And I had many cases where people would have a couple of convictions, never served a day in jail other than maybe the day of their arrest. And they come in front of me and they're looking at a mandatory life sentence unless they would cooperate with the government and provide them information on other people. And then the government the prosecutors have discretion to make a motion so that I could give something less than a life sentence. So, questions, comments, observations? Don't be shy.
Well, I'll start off with a question. I'd like to know then what you intend to do with this experience. Is it being replicated by any other judges? Are you keeping careful notes so that you can write a book someday? And are you going to try and seek some changes through some avenue in the federal system?
Thank you for that question, Jonathan. Yeah, after I started visiting the inmates, you know, the culture of federal judges was to not speak out on issues. And we're probably, well, without question, the judiciary is the least transparent branch of the three. The executive isn't exactly transparent. Congress may not be, but judges are almost all shrouded in secrecy. So I decided, the first time I spoke out, I think I wrote a letter to the editor that was published, it wasn't the New York Times, but I don't recall because I wrote several letters to the editor. And I actually checked it out with the ethics committee. And I decided that not only was it not unethical to speak out, but because I had specialized knowledge being on the front lines of the war on drugs, I felt I had a duty to speak out. So I started writing letters to the editor, articles. I appeared on several national TV shows speaking out against the war on drugs, did some interviews on talk radio shows in Europe, and then wrote several articles that were published in various magazines, and wrote a bunch of law review articles, and started working on Congress by writing letters about what I thought they should do in terms of sentencing reform. I got a lot of pushback from my colleagues for speaking out, which was fine. I expected that. But when you have life tenure, you don't really worry too much about what other people think. So I continued to speak out and advocate for criminal justice reform. And several of the things that, I had a few colleagues that agreed with me, but they had a hard time speaking out. And I did write an article about my visiting prison inmates that was published in Judicature, which is a magazine for judges, and it's sent out to all the federal and state court judges. So I had about half a dozen judges contact me about my experience visiting inmates. And I even had a judge ask me if I would take that judge to some of the prisons that I was going to, because she had several inmates in the same prisons. And so I took her, and let's just say this, it wasn't her cup of tea. She never wanted to do it again and never went back. It just wasn't for her. But I have federal judge in Kansas City started doing it, and I've heard from several others, but it's not been exactly a tidal wave. But I think unless you actually go to federal prisons and find out about their programming, and I wouldn't just meet with the inmates, I would meet with staff, particularly on the programming part of it and on the mental health part of it, because most inmates, or a good portion of them, not only do they have drug issues, but they have pretty severe mental health issues. And so I got to learn a lot about federal prisons, and my view essentially was, well, I had to protect society. Not much good happens in federal prison unless inmates are willing to participate in the programs. And so it changed my sentencing philosophy, and I even became, I guess, more lenient and gave shorter sentences, which originally, after the guidelines became voluntary or advisory, I was reversed repeatedly for the sentences that I gave. The Circuit Court of Appeals, very conservative, thought my sentencings were too lenient. And then several of my cases went to the United States Supreme Court, and the Supreme Court sided with me in each one of them and reversed the Eighth Circuit. And so the Eighth Circuit was forced to really change and started giving judges very wide discretion. And after that, a series of 3 or 4 cases where the Eighth Circuit was reversed and I was affirmed. The government stopped appealing my sentencing decisions. And so I pretty much had much more discretion to sentence appropriately. Jonathan, I did not keep good notes. I regret that. I wasn't a note taker in college or law school. I wish I had taken good notes, but I recently published an article. I'm trying to think of where this article was. It was at the Washington and Lee Law School out in Virginia, did a symposium on federal criminal justice reform. And I was invited to speak there, and I wrote a law review article. And the article is a composite of the interviews I had with inmates. And so the article isn't written in my voice, it's written in the voice of many of the different inmates that I have visited and kind of what happened in their cases. So it's written solely, it's something like, I can't remember the title now, but Voices from Federal Prison, something like that, a judge's experience with visiting inmates, something like that. So I've written about it, and oops, I don't know what happened here. Let me get back in. And so I've written about it and continue to write about it and continue to work on justice reform issues wherever I can, speaking out about it, and continue to write about it and urge Congress to do more. There's a thing that was passed 2 years ago, the First Step Act. They really need a Second and Third Step Act. Some of the reforms have been helpful, but there's a long ways to go to reform the federal criminal justice system.
I have a follow-up question.
Sure.
You have spoken about your sentencing experience and even the fact that you may have gotten more lenient as you have gained experience about the sentencing. I'm curious, given a current dilemma, what do you think about giving someone a reasonable sentence and then they go off to prison and they are in a petri dish for COVID-19 and their lenient sentence that you gave them turns into a death sentence?
Yes.
Comment?
Yeah, some judges are releasing defendants, but I don't think it's caught on. I would think for I would, and the Bureau of Prisons is releasing some folks early, but they should be much more aggressive about it. Yeah, you don't want an 18-month sentence to turn into a death sentence. And, you know, it spreads like wildfire. You know, it's not much different than nursing homes. And so I think unless there are compelling contrary reasons, nonviolent offenders, particularly those that received, you know, sentences maybe under 5 years, should be released on home confinement. If I were the policymaker, I would do that.
Mm-hmm.
You know, the interesting thing about the war on drugs, some statistics, when the sentencing guidelines went into effect on November 1st, 1987, if you look at the Federal Bureau of Prisons, 20-year period prior to 1987, their average census was about 30,000 a year, and it never varied by more than 5 or 6% over that 20-year period. Then in 1987, when the guidelines went into effect, they also passed major mandatory minimums in 1986. And so by like 5 years ago, the Federal Bureau of Prisons population had gone from 30,000 to 217,000. Now the federal system is, about 1% of all the inmates nationwide. The United States has the highest incarceration rate of any country in the world, exceeding North Korea, the Soviet Union, Saudi Arabia. I mean, it's just mind-boggling. The state of Louisiana has incarcerates more people than 90% of the nations in the world. So our incarceration rate is really off the charts. Now, because of the reforms in the federal system over the last several years, the population has dropped from 216 down to about 170,000. But 50% of the defendants in federal prisons are there on drug cases. And in my career, I sentenced more drug offenders than 95% of the federal judges in the country. I can count on one hand the number of so-called kingpins that I sentenced. And the mandatory minimums were originally designed for kingpins, but the quantity levels are so low that triggers them. You catch, the nonviolent addict offenders who are either manufacturing meth or buying meth in small quantities, not to sell to others, but just to support their own habit. And they get caught up in these federal drug conspiracies because they're the easiest ones to catch. And that's why the Bureau of Prisons population is so much higher than it should be.
Mm-hmm, mm-hmm. And then a follow-up on that, if you don't mind, the correlation between the war on drugs on the one hand and other kinds of crime, such as robberies and burglaries and the like, to get the money to feed the habit. If we are successful in our war on drugs by catching kingpins and shutting down their operations and interdicting their supply lines and so forth, does that just correlate to driving up the price of the drugs and in turn prompt people to do more burglaries and more robberies and the like to feed their habit? Is there a correlation like that?
Yeah, there probably would be. We haven't made much progress on the war on drugs because the focus has been on the supply side, and the cartels are going to outsmart the government 9 times out of 10 in terms of getting the drugs into the United States. So if you just focus on the supply side, it does very little on the demand side. And so, and treatment is difficult. Most meth addicts are not going to overcome their addiction the first or second time. It takes a while. But I've had some real great success stories. And one of the rewarding things about being a federal judge in a small town like Sioux City, 85,000, I couldn't go a week, after several years, I couldn't go a week without running into either a defendant that I had sentenced who was out or family members of somebody I had sentenced. And so part of my public service, the airport, for example, in Sioux City, for years didn't charge in their parking lot. It was just a flat surface lot. You just pulled up, didn't get a ticket. You just went in and you could park as long as you want. They finally decided to charge for parking. So the first time I went through the lane and rolled down my window to give the ticket to the person, she said, "You're Judge Bennett, aren't you?" And that was never really a good thing when somebody would say that. I said, "Well, yeah, I am." "Well, you sentenced my son, and I don't understand why that's such a long sentence." And I said, "Well, write down your son's name for me. And if you want, I have some time tomorrow afternoon. Are you working?" "Yes." "I'll come back here and we'll go through the pre-sentence report and I'll explain why he got the sentence he did." And I did that dozens and dozens and dozens of times, either inviting them to the courthouse or meeting somebody for coffee and then explaining why they got the sentence they did, let them read certain parts of the pre-sentence report. It wasn't a public document, but as long as I didn't give them a copy, it was okay. And I would explain the sentence. And I thought that was really a great public service, and I really enjoyed doing it. And then occasionally, I had this great experience where I was in Walmart, and I just checked out, and I was getting ready to walk out, and a Hispanic gentleman ran up to me. And I was just a little nervous because he was coming straight for me, and he stopped, and he goes, "Are you Judge Bennett?" And I said, "Yes." He goes, "Well, you sentenced me 10 years ago. I've been out. I'm off supervised release, which is the equivalent of kind of parole. And you really cut me a huge break, and I'm doing really well, and I'm working. And my wife and daughter are back in an aisle. Would you come back? I'd like you to meet them." So I came back. I met the family. They all wound up giving me hugs. I hugged the defendant, and it was kind of a love fest. And so it was really great to see people doing well, because mostly we saw people who, when they were on supervised release, had serious violations, were back in front. Sometimes I give them a break, but sometimes I give them too many breaks and I wind up sending them back to prison. So it was really fun to see the people who did well.
Excellent. Are there any other questions? Anyone? It's been a great
I'm
fireside chat.
curious.
Someone?
I'm curious what you think the future of drug policy and it could be, realizing those may be two different things.
The future of drug policy in the United States? Well, I hope they'll develop better treatment options to help break the addiction cycle. So not only potential drug treatment for drug addicts, but cognitive therapy that actually works. And so I would hope that we would move more towards a medical model like the Scandinavian countries do, and consider it a public health issue, drug addiction, rather than a federal criminal offense. I mean, large scale, major drug dealers, fine, that should be a federal crime. But for these low level, folks who are addicts, nonviolent, have no history of violence, they need major treatment that's been verified, that actually works. And so I would like to see the country move much more towards a treatment model than a punitive punishment model.
Judge Bennett?
Yes.
I know there's lots of research about racial disparities and things like that. Could you speak to the fact that a lot of people in jails are there because they're poor, so it's more economic disparity, that they are spending time in jail because they can't afford bond, where someone who has a higher income would just bond out and be out? And does that bonding policies basically protect wealthier people and sort of harm poor people? And the fact that bonds companies basically make money off poor people. Could you speak to that?
Yes, it's a huge problem. It actually isn't a problem. The racial disparity is a problem in the federal system, but the bond and the release of people is not. So in the federal system, unless you're a flight risk or a danger to yourself or the community, you're released almost always on an own recognizance bond. So there's no bond person involved. People just simply sign a promise to pay the bond if they flee, and the bond is revoked. So in the federal system, we never use money as a way to keep people incarcerated, either on pretrial release or once they're sent to prison. In the states, it's a huge problem, but it's being addressed in a number of states. So yeah, $100 bond for some people, they just don't have any money and they can't make it. So bonds disproportionately affect minorities and people who simply can't afford even a low bond, but a lot of their bonds are set ridiculously high. And so that's a huge problem. Let me talk about the racial disparity. The major racial disparity in federal court was this, I'm sure most of you have heard about this 100-to-1 crack powder ratio. So a gram of crack cocaine is weighed 100 times kind of worse than a gram of powder cocaine. So here are the numbers. Powder cocaine users are primarily Caucasian, and crack users are primarily African American. So I sentenced several hundred crack defendants in the course of my 24 years, all of whom were African Americans. And I was the first judge in the country to deviate from the 100-to-1 ratio after the guidelines became advisory. And so I went down to a 20-to-1 ratio, which had a huge impact on the sentence of the defendant. Stephen Spears was his name. And the Eighth Circuit reversed me, said I didn't have authority to go to a 20-to-1, and forced me to resentence them. So I resentenced them to, again, to 20-to-1, but came up with a hopefully better rationale. Got reversed again, and then the case went to the United States Supreme Court. And they said I was well within my discretion to deviate from the 100-to-1 down to 20-to-1. And then the next day after the Spears case was decided, I went to a 1-to-1 ratio. So that dramatically reduced the sentences of crack defendants. And then the government never appealed my 1-to-1 ratio, and I continued to use that ratio. Now, I would start with the 1-to-1. The empirical evidence is that crack cases tended to involve defendants who had a greater history of violence, greater history of using firearms in connection with their drug activity. So while I started with the 1-to-1, sometimes I would go up based on those other factors that I felt were race neutral to a certain extent. And so, and then Congress finally reduced that ratio from 100-to-1 down to 17-to-1. That was called the Fair Sentencing Act. And even after that, I wrote an opinion saying that it was just a political compromise. It's not based on any scientific data. So I continued to do the 1-to-1 ratio even after Congress went to 17-to-1. And again, the government never affirmed, appealed my 1-to-1 ratio, and I continued to do that up till the day I retired. But even in federal court, the Sentencing Commission did a study 2 years ago. I do a lot of empirical research in my new job, a very well crafted study statistically using multivariate regression analysis, and found that across all case types in federal court, Black defendants receive a sentence that's 19.1% longer than similarly situated Caucasian defendants, and Hispanic defendants receive sentences that are about 5.5% longer than similarly situated Caucasian defendants. So there's still a lot of, and of course that has a disproportionate effect on minorities and the poor. My explanation for that is implicit bias. I'm the only researcher who's ever done a study of federal judges. And I did a very comprehensive empirical study and found, in that case, we used, my co-author and I used an Asian defendant, a Jewish defendant, a Caucasian defendant, and a mainstream Christian defendant, identical pre-sentence reports, except those were the independent variables. And we found that, and we also had judges take the implicit association test, which measures your level of implicit bias. And we found that federal judges, we actually studied state court judges too, both if we combined all the cohorts or did them separately, it was essentially the same. And judges had stronger anti-Asian and anti-Jewish implicit biases than members of the public. and that their sentences reflected their implicit biases. In other words, there was a very strong correlation, and we could actually say causation because of the multivariate regression analysis that we used, that the stronger the subconscious implicit bias, the longer the sentence.
Judge, we have one question from chat.
Great.
Relevant to all of us. Says, please address your thoughts about mandatory return to work during COVID-19. Does that violate a worker's individual right to have a safe work environment, including the legality of losing your unemployment benefits if you do not follow the mandate to return to work?
Yeah, that's a great question. And when I got up this morning, I opened up the Des Moines Register, and there was an article about they're clarifying now who's going to get benefits and who's not. I think anybody who has a reasonable basis or fear of the coronavirus in terms of going back to work my own view is that they should be paid until the problem goes away. But if the employers can't afford to pay them, they should definitely get benefits. And nobody who has a good faith belief about going back to work and literally having a chance of getting a death sentence, often for a minimum wage job, should be allowed to collect full employment benefits. I think it's unconscionable. And this whole meatpacking thing, I guess the industries are doing something. They're putting up shields for individual workspaces, which if you've ever been in a meatpacking plant, that didn't exist. So I think they're trying to make it safer. But I think any employee who has a reasonable fear of getting the coronavirus should be able to not have to go back to work and be able to collect unemployment benefits. It's unconscionable to make someone work in a situation where they're likely to get the virus just because they have to try and feed their family. Anything else?
Other questions? If not, I'll bring it to a close here, and I want to express my personal appreciation to you, Judge Bennett, for doing this and for indulging the virtual meeting format. It was extremely interesting. It was extremely worthwhile to sort of get a glimpse into the inner workings of your judicial career and what you have done with it, including this prisoner visitation program that you have done. I think there's almost certainly a book in there somewhere. And I think you have give that some serious consideration. You have given our members a wonderful glimpse into your career and the insights that you have drawn from it. I'll just mention one thing that is on your signature line on your email that says a lot about this judge. He quotes appropriately, "The arc of moral universe is long, but it bends toward justice." And then it adds, "But the thing is, it does not bend on its own." Judge Bennett referred to himself as a person of action. And that quotation, it seems to me, captures that character. And we want to thank you for your years of service and for the insights that you've provided from this experience. Thanks.
Well, Jonathan and everyone, thank you so much for having breakfast with me, virtual breakfast with me this morning. And I'm very honored to speak to the First Friday Breakfast Club. And I appreciate the kind words from Jonathan. Jonathan is somebody that I don't know well. I consider an acquaintance, but I've always had great admiration for you, Jonathan. And I thought when you came out publicly, I believe you were still on the school board at the time, my admiration for you skyrocketed. It was already high. I just thought it took a tremendous amount of courage. And you think about where we were then, Jonathan, when you came out, and where we are now, it's been a tremendous difference, and the country is much more tolerant. We have a long ways to go. The fight, a lot of battles need to be fought, but it's people like you, and I'm sure other members of the First Friday Breakfast Club that displayed tremendous courage, and you have my unyielding admiration. Thank you very much for having me today.
Thank you.
Thanks.
All right. This has been very informative. This virtual thing does work. I think we can get better at it. It has been both last month and this month a great opportunity for some interactions with very capable, outstanding people. So we will keep you informed about what we are going to do for the June meeting. Our speaker in June is Dr. Ryan Wise. He's the executive director of the Iowa Department of Education, and he is the incoming chair at Drake University's Department of Education. He should be an outstanding speaker, and you'll all want to participate one way or another. And we will keep you informed of what the board decides to do about that June meeting. If there is nothing else, we will adjourn our meeting today, and thank you again for your participation.